Their draft minutes are available, pages 6 to 10. If you're content with their accuracy, I'll sign them accordingly. Agreed. Matters arising. Item 1, there was correspondence from the Director of the BBC for Northern Ireland. That was from Peter Johnson. Following a meeting that the committee held on the 20th of February, a copy of the letter is on pages 12 to 13. Peter Johnson has made further inquiries based on the information regarding the text messages that had been provided to him at that meeting, and he's confirmed that the material referred to had previously been shared with the PSNI. Mr. Johnson also referred to an approach by a local print journalist following the closed session of the committee meeting, when he was asked very specific terms about the meeting, including details of questions asked, the information presented, and his response to some of the issues that were raised during the discussion. Mr. Johnson indicated that it was his assumption that closed sessions of Assembly committees remain confidential, and he has asked for the committee's view on the disclosure of details relating to the closed session, what confidentiality expectations witnesses can have in engaging with Assembly committees, and whether the Justice Committee has any concerns about the fact that detailed information about this particular session seems to be have been made more widely available. So again, Mr. Johnson makes a valid point. Items dealt in closed session should obviously remain dealt in closed session, and he has highlighted his concerns to the committee in respect of that. However, I'm not the police, and I'm not here to investigate members if anybody leaked the information. But nevertheless, I would encourage members to keep matters confidential, and obviously the committee did treat this matter confidentially up until this point, but obviously Mr. Johnson has felt the need to write to the committee, which has obviously led to it now having to be discussed in a public session. And I know Bernardo's did contact me because they were very concerned about the reporting by the Belfast Telegraph that it was inaccurate, and libelled Bernardo's because they reported it as saying that the abuse had taken place in Bernardo's homes, and they were very upset at the way in which the Telegraph had reported that closed session, and obviously they have had to print clarification around that particular matter. So just bear in mind, members, to try and keep things in a closed session. Item 5 is oral evidence on the Human Trafficking and Exploitation Bill, and we have officials with us today, and they're welcome to come to the table. The bill and its memorandum can be found at tab 1 of the bill folder, and we will try to structure this by working through clause by clause as a way to try and get the best information from officials who are going to outline the department's position in relation to each particular clause, and then obviously members will be able to ask questions around those individual clauses. So members can bear with me as we go through each clause, and we'll try to structure it in that sense. So let me formally welcome Simon Rogers, Deputy Director of Protection and Organised Crime Division, Gareth Johnson, Director of the Criminal Justice Policy and Legislation Division, Julie Wilson from the Policing and Organised Crime Division, and Amanda Patterson from the Criminal Justice Policy and Legislation Division, all from the Department of Justice, to the meeting. You're very welcome. The meeting will be recorded by Hansard and published in due course, so I'm going to hand over to yourselves at this point, and then we'll take up the issues.
Thank you, Chair. The Department has been asked to brief committee members on the Minister's response to the committee's evidence sessions on the Human Trafficking and Exploitation Bill. In October last year, the Department provided a written paper in response to the committee's call for evidence, and that paper indicated that the Minister was supportive of the motivation and sentiment behind the bill and welcomed the bill's positive impact in terms of raising public awareness. The Minister supported many provisions, but also highlighted a number of areas of concern. Since that time, the Minister and Lord Morrow have been engaging on the content of the bill to agree amendments in order to resolve those areas of concern where possible. and good progress, we think, has been made, and the Minister and Lord Morrow wrote jointly to the committee members on 14 January, setting out the areas in which they had reached agreement, some where engagement was ongoing, and one where agreement was not reached. In the written paper provided for today's session, we've set out the Department's detailed clause-by-clause response to the bill, highlighting the areas where the Department intends to table amendments and to what effect. We understand from the contact with Lord Morrow that he also intends to table a number of amendments to the bill, and we've sought to highlight these too. I don't intend to repeat the points in the letter in depth, but it might be helpful to draw out some areas for the committee. The first is really to remind members of the Minister's consultation on new measures to add to this bill and further strengthen our response to human trafficking and slavery. We briefed the committee on these in January, and in summary, the proposals which are out to consultation would simplify the legislative framework, increase the maximum sentence, introduce new court orders to protect the public, provide effective oversight of government and law enforcement action, and enhance our understanding of the extent of offences in Northern Ireland through data capture. Subject to the consultation and the committee's views on that, and to timing, as we've explained before, our preference would be to legislate for these proposals, if possible, through amendments to the bill before you today. Lord Morrow has indicated that he is sympathetic to that approach, and we're confident that the proposals that I've just outlined would complement and strengthen the bill. Some would, as we've explained, have a direct impact on the bill as well, and we think that that's why it's preferable to amend this bill rather than having to amend a subsequent act. Clauses 1, 5 and 14 of Lord Morrow's bill in particular would require amendment. Turning now to the bill, I want to just focus on three main areas which remain of concern to the Department. Clause 4 deals with minimum sentences. In summary, it provides for a mandatory minimum sentence of 2 years for human trafficking and slavery offences. The Minister intends to oppose its inclusion in the bill on the basis that judges should be free to take full account of the potentially broad scope of circumstances of each case in delivering a sentence. Nonetheless, he recognises that the clause may be supported by the majority in the Assembly. It's important, therefore, to highlight our most serious concern about the clause, which is that, as currently drafted, it would apply to children as well as adults. And the Minister's strong view is that children should not be subject to the same sentencing framework as adults. Lord Morrow has acknowledged the Minister's concern on this, and we understand that he intends to table an amendment to disapply the provision under Clause 4 to children. Clause 8 concerns the non-prosecution.
Simon, we'll get to Clause 8 and what are the other one as we go through it. I'll ask you to comment on each individual clause. So, if you're happy, that's the approach I take to try and keep members so that they don't jump from clause to clause either. So, if you're happy with that approach.
I was trying to help the committee by just highlighting the three areas that, from a department's perspective,
I think
we're concerned, but I'm happy to pass on if that's
I understand the committee staff that advise the department will go through each individual clause rather than just highlighting their particular ones, because we'll get to them.
Okay.
So it avoids repetition and it just helps us to be more efficient.
Of course.
Okay. Then if you want to start on Clause 1 for me.
Okay.
That's definition of human trafficking and slavery offences.
And in terms of Clause 1, we don't have any proposals for any amendments to this. The consultation we're undertaking would have a bearing on it, but as it stands, we've no concerns about Clause 1.
Okay. Your original submission, you indicated recommending amending Clause 1B so that other relevant offences under Sections 12 and 13 of the Gangmasters Act 2004, but you're not now doing that. Can you indicate why?
We had another look at it and we took legal advice on it, and the nature of those offences we didn't think would be relevant to the the other provisions, which Clause 1 and the offences under Clause 1 would capture. So they are linked in nature, to exploitation, but the level of the offence would be different, and we didn't think it would attract those other provisions under parts 2 and 3 of the bill.
Okay. Any members have question on Clause 1? Well then, let's go to Clause 2.
Clause 2 specifies the circumstances in which a victim's consent to any action related to being a victim of human trafficking and slavery should be deemed to be irrelevant. And again, we've no comments on it. I would say no amendments we're proposing.
Okay. Any members a question on Clause 2? Okay. Clause 3.
Clause 3 is on aggravating factors and would require the court to treat a range of specified factors as aggravating factors when sentencing for human trafficking or slavery offences. Our position on this had been that there is sentencing guidance already available through the Crown Court, but we've looked at the weight of opinion that's coming through this committee on the clause, and the Minister's reflected on that, and while he's wanted to highlight the fact that aggravating factors, strictly speaking, didn't need to be expressed in statute, he wouldn't propose any amendments to Clause 3 or indeed oppose it.
Okay. So I'm assuming then the Department will be supportive of Clause 3?
Yes.
Okay. No other? Mr. Elliott?
Chair, I recall a question around this about more flexible sentencing guidelines or use of sentencing guidelines. Has the Department moved away from?
Well, our view was that aggravating factors are better dealt with by the court, and indeed in the case of our against Peace, the recorder at the time, Judge Burgess, set out the aggravating and mitigating factors for this offence. But I think the Department is trying to show a spirit of cooperation and support for this bill rather than to look like it's being negative about it. And if the general view is coming across to us that people would like to see aggravating factors, we're not going to stand against those.
Yeah. You still think it's wrong, but you're not going to object to it?
We're not saying it's wrong. What we're saying is that there are the normal form for stating aggravating and mitigating factors is through sentencing guidance rather than statute. That isn't always the case. There is some statute that covers aggravating factors, and in this instance, the Minister's taking the view that he can work with Clause 3 as it stands.
Okay.
Okay.
Thanks, Chair.
Do you want to just recap on Clause 4 for me then, Simon?
Sorry, yes. Clause 4 would introduce a compulsory minimum custodial sentence of at least 2 years for any human trafficking or slavery offence under the bill, unless the court were of the opinion that there were exceptional circumstances to justify it in not doing so. As I was saying, the Minister's view is that judges should be free to take account of the potentially broad scope of circumstances in each case in delivering a sentence, and he doesn't support Clause 4 for that reason. He has, however, indicated and agreed with Lord Morrow that the provision shouldn't extend to children, and Lord Morrow has indicated that he would propose to table an amendment to that effect, which the Minister certainly would support.
Mr. McGinnis?
Yeah, I just want to clarify this. It seems to me that this is not, strictly speaking, a compulsory minimal custodial sentence. It seems to me that where you have the phrase unless the court were of the opinion that there were exceptional circumstances to justify it in not doing so, is that not a qualification, a sufficient qualification of that, as to permit sufficient judicial discretion in relation to sentencing?
It does, and often sentencing guidelines will give that option as well. In cases, I think the view of the department is it's better not to have a whole raft of statutory provisions which then have an exception in them, and that it would be better to leave this discretion entirely in the hands of the judiciary.
Yeah.
We've already set out, in, for example, that case I mentioned of Ark against Peace, that what the aggravating and mitigating factors are.
Yeah.
So I think almost as a principle, the department doesn't favour minimum sentences, and they are quite a rare occurrence in statute at the moment.
Chair, I agree with that position. I don't believe that there really should ordinarily be mandatory sentences. But I think that this is sufficiently qualified that it doesn't fit into the category of it being strictly a mandatory sentence because of the exceptional circumstances aspect of that particular clause. So I think really, I mean, the department isn't. Does the department agree with me in relation to that? I mean, that
the Minister's intention is to oppose this because he doesn't think it's a good principle to have a minimum sentence in this case, or indeed to start extending minimum sentences across other criminal offences.
You're not accepting.
We recognise.
You're saying this is a mandatory minimum sentence.
We recognise.
In all intents and purposes.
Yes.
Okay.
And the difficulty is if every case becomes an exception because the judiciary think 2 years is too grave because of guilty plea or whatever, all the circumstances of the case, then our concern is that the exception becomes the rule.
Okay. Thanks, Chair.
Raymond?
I just when you said it was a rare, there's a minimum sentence, how rare would it be?
The only other one I'm aware of is in in the firearms order and dates back to the 1970s in a statutory situation, and we couldn't, looking at Gareth, because he might know of somebody, that was the only one we could turn up.
I mean, there's an extent to which, with murder, a life sentence follows, but then you have discretion in terms of the tariff that's awarded there.
No, because no exception for this, in terms of Albyn's contention, for it not to be seen as a mandatory or minimum sentence, then exceptional would have to be defined, or it's, everybody will find an exemption to do it. Like, that's my only concern. Like, so. Okay.
Okay, thank you. Clause 5.
Clause 5 makes amendments to the Asylum and Immigration's Treatment of Claimants, etc. Act 2004 on the definition of trafficking and exploitation. We don't have concerns about the intended effect of this. However, the consultation we're undertaking at the moment would itself introduce a new consolidated offence, which would have an impact on Clause 5 if, through the consultation, that proposal is accepted. There are a couple of, there's one at least minor technical amendment which we've set out in the advice or paper to the committee around positions of trust, which we think needs to be tidied up. And Lord Morrow, we've been working with on that and agrees with us that should be tidied up.
Any member to question on 5? Okay. Clause 7.
Clause 7 would place a statutory duty on the department to ensure that appropriate training is provided to those responsible for investigating and prosecuting offences of human trafficking and slavery, and that effective investigative tools are made available. I mean, while we recognise the importance of training and resources being provided for frontline professionals, and indeed that's reflected in our action plan at some great extent, in which priority is given to training and investigation and prosecution, our concern is that Clause 7.1 places a duty solely on the department that actually it's not able to deliver since the organisations and agencies that the clause is intended to cover are wider than the authority of the department. The Ministers discussed this with Lord Morrow again, and they've agreed that the issue would be best addressed, the Clause 7.1 issue would be best addressed by an amendment to Clause 15, which is around prevention, to require the strategy under that clause to include training, investigation and prosecution. And so we would be seeking an amendment to omit Clause 7.1 and amending Clause 15. We have no concerns with clauses 7.2 or 3.
Lord Morrow's content with that approach?
He is, yes.
He is, yeah.
Yeah.
Okay.
Sorry again, sorry, Chair. Which part are you removing?
7.1.
7.1.
So the statutory duty for training.
Yeah, okay.
And amend clause 15.
And then clause 15.
Yes.
Okay. Other members on that one? Clause 8?
So, no.
Clause 8 would provide immunity from prosecution for victims of human trafficking where they've been compelled to commit a criminal act as a direct result of being subjected to threats, abduction, fraud, deception, the abuse of power or of a position of vulnerability, or the giving or receiving of payments or benefits to achieve the consent of a person having control over another person, or where the victim is a child. This is one of the areas where the Minister's expressed significant concerns, because he feels that it would fetter the Director of Public Prosecution's current obligations under the Justice Northern Ireland Act 2002 to review each case received in accordance with the Code for Prosecutors in order to determine whether criminal proceedings should be instigated or continued. The clause indeed would go beyond our obligations under the EU directive, in that they don't require member states to ensure immunity, but rather to ensure that prosecutors are entitled not to prosecute or impose penalties on victims, and that is already the case here. Obviously, under the test for prosecution, the DPP would consider whether the public interest calls for prosecution and punishment, and we are aware from the DPP's office that there have been cases where there has been no prosecution where the person concerned was a victim of human trafficking. In addition, as the committee is aware from evidence put to it, the Attorney-General's draft human rights guidance for the Public Prosecution Service also deals specifically with this issue. Our concern is that Clause 8 doesn't provide a proportionate or appropriate response in that it would introduce a less nuanced and fact-specific approach to the crimes than is presently available. The Minister's discussed this with Lord Morrow, and he's confirmed that it wasn't his policy intention to provide a mechanism for blanket immunity, but rather to ensure that the victims are protected from prosecutions that are not in the public interest, in cases where they've been compelled to commit offences. The Minister shares that view, but the Department believes that the protections are already available. We don't support the clause, therefore, and it's an area in which we're in continuing discussions with Lord Morrow. We're also in discussions with the PPS to see whether the guidance that they've actually issued could be strengthened in some way. So in short on that, the Department wouldn't support Clause 8.
Okay. Any members' questions around Clause 8? Mr. Elliott?
Chair, thanks. It was one I had a specific interest in. I'm just wondering, well, you're not supporting it. You did say there's ongoing discussions with Lord Morrow. Are you coming any closer to a resolution on it? I'm assuming, and again it's only an assumption, that he's planning to keep it in, but maybe make amendments to it. Is that right?
I think Lord Morrow has said that he also wants to be informed by any recommendations that are coming out of the Joint Committee in Westminster, who's looking at the Modern Slavery Bill, that are also considering this issue. I mean, some of the things that we've been looking at involve really, I mean, we share the same policy intent in that we would want to avoid victims of human trafficking being prosecuted where that's not in the public interest, and we think there may be issues around awareness in the criminal justice system. So we've already begun to do some things around that. We've written to stakeholders across the criminal justice system to highlight the issue, but we're one of the things that we've been considering is whether those kind of raising awareness across the criminal justice system could be covered under the annual strategy in Clause 15 as well, and whether we could maybe amend Clause 15 to require that strategy to look at those kind of issues as well. We're also aware that Crown Prosecution Service has just issued more detailed guidance on this, and so we've written to the Director of Public Prosecutions seek his view as to whether similar guidance would be helpful here as well.
Okay.
I must say a lot of sympathy with the department in relation to this, because you could find, if there is a blanket immunity granted, you could find people who have carried out serious offences, although originally victims of human trafficking, but have, gone over to support criminal activity. You could find these people guilty of criminal offences and exercising immunity where, in circumstances, it's totally inadequate. We heard some good evidence in relation to this in this session in the Long Gallery, and perhaps we should revisit some of that evidence just to see if there's a way forward on this. But it seems to me that probably the best way of dealing with this is to look at the prosecutorial guidance, and if that is weak, to strengthen it in order to safeguard genuine victims of human trafficking.
Well, we can do that.
Chair, sorry.
Sorry.
I was going to say, Chief Superintendent Roy McComb in the evidence session here highlighted the risk as well that every defendant is going to argue, I'm a victim of human trafficking, to open up a new line of defence, if you like. Yeah. And that would be another concern. I mean, the objectives that Lord Morrow is seeking here, we are fully supportive of, which is that victims of human trafficking, who as a result of that have committed some offence, should not be prosecuted, and the PPS are at one with us in that. The risk of Clause 8 is much further than that objective.
Ms McCorley?
Yeah. The same, I've sort of similar concerns around this, creating a blanket immunity, because then it's hard to cover every single eventuality. And I was wondering, you say in the same circumstance where someone might be arrested for an offence and then say, I'm a victim of human trafficking, and are they automatically put into the national referral mechanism, which can take maybe up to 90 days? Will that prosecution be pursued while that person's in the referral system?
Within the national referral mechanism, there's the two stages. So before you get to the kind of 45-day recovery and reflection period, you need first to satisfy a reasonable grounds test. So I mean that has a lower threshold to prove, but there would still be some evidence required to satisfy the competent authorities in those cases that that individual does have there are reasonable grounds that individual is a potential victim of human trafficking, and the actual recovery and reflection period doesn't actually begin until that reasonable grounds test, which is supposed to be carried out in 5 days, has been that decision has been made, and then you get the longer 45-day plus period until a conclusive determination can be made as to whether that person's an actual victim or not. So the two-stage process there does help, I think, and would identify those people who may be making a claim that they're a victim where really there isn't the evidence to suggest that that there are reasonable grounds.
Has it ever happened that someone who claimed to be a victim then with human trafficking, and then a decision made against that, then they've gone on to be prosecuted for an offence. Has that ever happened?
Don't think we know the answer to that. We need to ask the Public Prosecution Service. We do know that they have not prosecuted individuals who were involved in sexual exploitation and labour exploitation. So they have examples. Now, we didn't ask them for too much detail on that, but we do know that is the case.
Yeah. Clause 9.
Clause 9 provides a definition of victim of human trafficking for the purposes of parts 2 and 3 of the bill. In effect, we're supportive of the clause, but we do think it needs some amendment. The current definition provided under Clause 9 would actually encompass both potential victims of human trafficking, those who have been referred into the National Referral Mechanism and who have received a reasonable grounds decision, and who are currently in the recovery and reflection period, as well as confirmed victims who have gone through the NRM process and have received a positive conclusive determination. So the Department is satisfied that the effect of the definition in Clause 9 is appropriate in respect of the requirements set out for assistance and support under Clause 10 and the Clause 12 requirement about the appointment of child trafficking guardian. However, we have some concerns that the current definition wouldn't have the appropriate effect in respect of other clauses under Parts 2 and 3 of the bill. So, for example, whilst we agree that the provisions of Clause 10 and 12 should be available both to potential victims under the NRM and to confirmed victims, we think that Clause 11, which relates to compensation, should really only apply in respect of confirmed victims, since not all potential victims may receive a positive conclusive determination confirming them to be victims. So the Department will be seeking an amendment which would set out separate definitions, so a definition for potential victims and a definition for confirmed victims under the NRM. And we've discussed this with Lord Morrow and his team, and he's in principle content with the intended amendment.
And the outworkings of that then, in terms of compensation for victims, how would that help them?
It would mean that clause of compensation, we think, should only apply where someone has been confirmed to be a victim, so rather than to people who are still going through that process and who may actually receive a negative conclusive determination. So it's about defining those two groups of people who will be entitled to supports, but our view is that those supports should be different according to what their status is.
Mr. McGuinness?
Yes, just in relation to compensation for victims of trafficking, there is who will give the compensation? Are you relying, or will this bill rely on the criminal injuries compensation scheme? And under that scheme, is there a provision in which a victim of human trafficking can be compensated?
Yes, there is, and indeed there are cases where they have been.
Yeah.
The issue Julie's raising in this area is that would apply to confirmed victims, yes, rather than perhaps what I might call speculative claims, yes, for someone who's not been defined as a victim. I mean, Clause 11 deals with the compensation point.
Yes.
And Chair, I don't know whether you want us to wait and come on to that, or
maybe we will.
That's okay. Yeah.
I would like to know a bit more about the compensation.
Okay, well then, let's go on to Clause 10.
Clause 10 would place requirements on the Department of Justice and on the Department of Health, Social Services and Public Safety to provide support for victims and potential victims of human trafficking. The Minister had already signalled that he was proposing to bring forward secondary legislation in this area, and obviously therefore is content with the policy objective behind Clause 10. We do think, however, there's some clarification needed between the respective responsibilities of the Department of Justice and of Health, and also to look at the language of the clause. And we're currently liaising with officials in Health with a view to seeking some amendments to clarify that. We've been discussing this position with Lord Morrow, who again is happy in principle, subject to seeing the detail.
Okay. Members? Okay. Clause 11.
Clause 11 takes us back then to the compensation and would require the DOJ to set out by order the procedures for a victim of human trafficking to apply for such compensation. The current arrangements are set out in the Criminal Injuries Compensation Scheme 2009. Lord Morrow and the Minister have discussed this, and they've agreed that Clause 11 could be amended to require the Department to bring forward statutory guidance as opposed to an order, and we're seeking an amendment to that effect. In addition, since there is in fact no requirement for an applicant to be resident in Northern Ireland in order to be eligible to apply for compensation, Lord Morrow has agreed that Clause 11B(2), which deals with leave to remain in the United Kingdom in order to claim compensation, should be removed. So we would propose as well to bring forward an amendment on that.
Mr. McGuinness, do you want to pick up on that?
Just in relation to the level of compensation, what would the victim of trafficking be compensated for?
We don't have figures, I'm afraid, but we can certainly provide them.
But currently, if, for example, I was a victim of human trafficking, I could currently apply to the criminal injuries compensation scheme.
Yes.
And I could receive a payment from them.
And that has happened.
And that has happened. Is that for being trafficked?
I think that's for the level of injury that's against you.
You see the point I'm making, that are you being compensated for injuries received as scheme is arranged for? For example, I was locked up and I was beaten up, this sort of thing, and suffered an injury. Is that the...
My understanding that is what the compensation is.
But you would not be compensated for being trafficked per se?
No, you wouldn't per se. It's down to injury, as you're alluding.
Yes. And there's lots of rules around receiving compensation. You have to see a doctor in certain circumstances. You have to have repeat visits to doctors. You have to show a level or a degree of injury which reaches a certain level of gravity that merits compensation. All those rules would still apply to people who are unaware of the scheme, unaware of the various hurdles that you have to get over. And
there is, though, a degree of flexibility around various rules. I mean, for example, one principle is that the matter is reported promptly to police.
That's right.
In the case of someone who has been held as a trafficked person and, as it were, imprisoned as a trafficked person, compensation services is going to have a degree of latitude there in terms of when the matter's been reported to police. You're not going to expect someone who isn't in a position to report to report. So I think that there is a degree of flexibility in those rules which allow an equitable approach to be taken in cases like this.
Well, Chair, I'm not aware of the flexibility shown by the...
I know in the evidence we received, victim support indicated all of these hurdles, and it was very problematic for victims of human trafficking to meet the criteria.
I just make the point that whilst I understand and the department is trying to be helpful here, I'm not so certain that the scheme as it presently is operated would be friendly towards victims of human trafficking, because there are so many different hurdles, evidential hurdles in relation to the level of injury, medical reports, etc. So maybe that should be looked at to some extent to see if in fact there could be amendments made to the compensation scheme so that traffickers would be able to benefit from the scheme.
It's,
I was just
We're all
think
about
that
to say
the
the
fact,
same thing.
well, the fact that there is to be statutory guidance, and
Yes.
that's the position that we've agreed with Lord Morrow, and these are the sorts of things which could be covered in the statutory
Yes.
guidance.
There is also a review of compensation legislation which has begun now. It's been focusing on criminal damage, but it's going to then look at criminal injury and victim support. I understand have said that review is, is the appropriate place to be looking at those issues, and certainly, that can consider the definition of crime of violence and things like that, and how trafficking victims are able to apply for compensation. So there is a review process there that will allow those issues to be looked at.
I mean, this might be too radical a step to take, but it might be appropriate to look at trafficking in itself being regarded as a criminal injury, which is compensatable to a certain degree. That might be a helpful suggestion.
we'll certainly feed that into the review team. The other thing, just very quickly to mention, is that in the support mechanism you would be signposted. Part of Women's Aid and Migrant
Yes.
Help would signpost victims to compensation and a whole range of other services, but that is one of the things as well, advice, etc.
Yeah.
Clause 12.
Clause 12 sets out a requirement that each child who might be a victim of trafficking in human beings shall have a child trafficking guardian appointed to represent the best interests of that child in specified circumstances. The Department of Health has overall responsibility for child protection, and this clause is really outside the remit of this department. But we understand that the Health Minister is supportive in principle and is engaging on this clause. From a Department of Justice perspective, we've no opposition to the clause, but it really falls to Health to take forward.
Clause 13.
Clause 13 would place a statutory duty on police to prevent secondary victimisation during police interviews by avoiding unnecessary repetition of those interviews, visual contact between the victim and the accused, and unnecessary question concerning the victim's private life. I mean, again, this is an area where the Minister previously indicated his intention to bring forward legislation, and again, no surprise then that he would agree with the effect of this provision. There is a slight adjustment in that we've suggested to Lord Morrow that an amendment to replace the phrase victim with the phrase the complainant in order to maintain consistency with terminology used elsewhere is advisable, and Lord Morrow has indicated that he would propose to make an amendment to that effect.
Clause 14.
Clause 14 is about special measures in court and is in a similar category. It would amend the Criminal Evidence Northern Ireland Order 1999 to ensure that victims are automatically entitled to special measures in court. At the minute, that would apply in cases of sexual exploitation, but not generally. Again, the Minister has intended to legislate. It's got the same issue around complainant and victim, and Lord Morrow has indicated again that he would intend to introduce an amendment to resolve that. This is another area where the current consultation we're doing might bite in, but as it stands at the minute, we certainly support Clause 14.
Okay. Numbers. Clause 15.
15 would place a statutory duty on the Department to publish an annual strategy on raising awareness of and reducing trafficking in human beings and slavery offences in cooperation with non-governmental organisations and other relevant organisations. In effect, it would replace the Department's current non-statutory commitment to produce an annual human trafficking action plan, and as such, the Department has no difficulty with the intended effect. Just to mention again, in respect to Clause 7, we've agreed that the strategy should cover training, investigation and prosecution, and as a result, we'd need to seek an amendment to that effect.
No members? All right. Next clause.
Clause 16's Lord Morrow has proposed here a Northern Ireland rapporteur, and this is one of the areas covered in our recently published consultation. Clause 16, as it stands, would require the Department to establish an independent rapporteur to report to the Assembly on the performance of the Act in Northern Ireland and related matters. The Minister has acknowledged the need for effective monitoring and accountability in respect of human trafficking. His current view, subject to the consultation that we're running, is a more effective approach would be to extend the remit of the United Kingdom-wide Anti-Trafficking Commissioner, which is provided for in the Modern Slavery Bill, to cover Northern Ireland. And as a result, he would oppose Clause 16, but in the hope of getting support for a wider Commissioner. Lord Morrow has acknowledged that the broader Commissioner may be a more effective approach, but seeking assurances about the nature of that body and appointments, etc., before he'd withdraw his own proposal about a local rapporteur.
Okay. Any members' questions on Clause 16?
I'll just make a comment. Surely in the context, is it not more appropriate that we have our own rapporteur who has a specific role in relation to these matters? Now, I understand, in the context of the anti-slavery bill, that there's going to be some sort of super rapporteur for the UK, but surely it'd be worthwhile having our own here.
I think the Minister's concern is that a number of the bodies who are integral to the organised crime strategy and the task force are UK-wide bodies, Border Force, HMRC and others. His view is to capture all of those references to have the broader Commissioner. He has made it clear, however, to the Home Office that he'd expect that Commissioner he'd expect to have a role in the appointment of that Commissioner in their terms of reference, in other words, the areas they're looking at, and also that any reports would have to be to the Assembly and the Minister here. So I think his concern would be not to have two bodies doing this, both a local and a UK-wide one, not least bearing in mind that there are a lot of other bodies that can trample on this ground, like the Criminal Justice Inspector, HMIC, Police Ombudsman, the Justice Committee, dare I say, and others. So there's, I think his view would be, on balance, the Commissioner, UK-wide, or a national rapporteur. I think he feels the Commissioner, because of the breadth of this issue, which is really a global issue rather than a local one, points to having the UK-wide Commissioner.
Thank you, Chair.
Okay. 17.
17 to general interpretation provision. And as we highlight in our paper, that we think there's a few amendments of a minor nature required to it. Clause 17.3, for example, provides that in cases where the age of a person is uncertain and there are reasons to believe that the person is a child, they should be presumed to be a child. This is a small point in one sense, but important. We believe that it would be helpful to clarify that they should be presumed to be a child pending verification of their age, and would seek an amendment to that effect. While Clause 9 seeks to define victim for the purposes of Parts 2 and 3, the bill doesn't currently include an overarching definition of victim of human trafficking, and we think it would be useful to put this in Clause 17. and we're looking at amendments on those.
Okay. Close. Just the orders that have
The
been
orders,
made,
really,
so
yes.
it's straightforward.
And points to affirmative rather than negative resolution.
Okay. And no changes to the title.
No.
Okay. Clause 6.
Clause 6 on the issue of regulating prostitution. The paper to the committee has set out the department's position. We're not arguing with the proposition that demand for sexual services may have a bearing on the supply of trafficked victims, and we note the support for Clause 6. But the department still has concerns, and they are concerns that have been shared by others, about legislating in this way without taking cognizance of the possibility of creating adverse impacts on an already vulnerable group of people. That's why we've commissioned research to provide us with more targeted evidence to use as a base for developing policy in this complex area, and the paper provides more detail on the precise nature of those concerns. Now, the department recognises the cohort of evidence that has been put forward in favour of criminalisation, as illustrated by the Swedish or the Nordic model, but is also aware that much of that evidence is contested. And the research is intended to address the issue of how such a change would sit within the criminal justice framework here in Northern Ireland. Now, the paper acknowledges the fact that previous research was carried out by the department in 2010, and it looks at the context of that research. It also acknowledges the evidence that was given just recently by the police to the committee. In concluding, the paper states that the Minister intends to oppose the clause to allow him time to consider the outcome of the research which we're commissioning.
Mr. Humphrey.
Thanks, Stuart. Thank you very much for your presentation. Can I just ask, you mentioned, Mr. Johnson, the research. Has it gone out to tender?
The research has gone out to tender, and the intention is to award a tender by the end of this month.
Right. So the person hasn't yet been selected. When will the research be completed?
The intention would be to complete it in the autumn. There's about a 6-month time scale.
The autumn, early, late?
It will probably be towards the end of October, November time.
Okay.
Just on that point, has the department ever used Graham Ellison for research?
In terms of who has applied for the research, who has submitted tenders, because that's all a currently running process, it's confidential to the tender evaluation panel.
But heretofore, there's never been any official research provided by Graham Ellison to the department.
Sorry, Chair, I didn't quite hear that.
Up until this point, before this tender process, has the department ever engaged with Graham Ellison around this issue?
There was a request from Mr Ellison to meet the Minister, and that meeting took place, and he briefed the Minister on the research that he'd been undertaking.
It would be open to him then, I take it, to apply for this exercise?
There's no reason why anybody couldn't apply to this process, provided they were suitably qualified.
If he is selected, well, you can bear in mind what he said to this committee and what he said about individuals in this committee in terms of then the credibility of any evidence that would be provided. That's a comment that you can note. Mr. Humphrey.
Thanks, Chair. You'll be aware that the PSINI has changed its position on Clause 6, Mr. Johnson. How does the department view or assess that change of position?
The PSNI has said that they're not opposed to Clause 6. They did qualify that by expressing some concerns about the impact that it might have and about the risk of unintended consequences. Some of the areas that were highlighted were around the fact that it was difficult to assess how much impact the threat of prosecution could have on behaviour. there was some discussion about the risk that prostitutes themselves, once you start to legislate, to regulate in an area, that prostitutes themselves might feel further ostracised and removed from police, and obviously they're very keen to keep those links and those relationships with sex workers, and to assure them that any offences against them will be properly investigated and dealt with. There were some points too about the flow of information, and those are all points that we want to get a grip on through the research before coming to conclusions on what the appropriate policy response would be.
Yes, but nevertheless, the police, you will accept the police have changed the position. You will accept that the police have changed the position?
Yes, yes.
Can I ask if the department is aware of the women's rights campaign, committee report from the European Parliament?
Yes.
Okay, and how does the department then respond to the support across the European Parliament? The motion based on that report was supported by 2 of our MEPs. I'm not sure what Mr Nicholson's position is, but it was supported by 2 of our MEPs, which promotes the criminalisation of the purchase of sexual services. What's your view?
This is
the
all
Department's view.
Yeah, it's all a contribution to the debate. It's a report that we've seen and looked at, and obviously we'll want to study further. I suppose it is just worth acknowledging that it is a non-binding resolution from the Women's Rights Committee. The other interesting point is just the wider recommendations which it makes in terms of, for example, how you support people coming out of prostitution. And again, this all points to the research, because we want to get a handle on those wider impacts which aren't part of the proposals in Clause 6.
But you think, in your reply, you talk about it being an unbinding. But at the end of the day, nevertheless, a clear majority members of the European Parliament supported that view. And obviously that they represent, the vast bulk of continental Europe. Just in terms of your responses today, I mean, this piece of research will be unbridled. Those who are selected by the department will be allowed to go out and carry out this research without direction or interference from the department, I would assume.
Yeah, the direction which is given is the terms of reference, the scope of the research, which is in the specification. I know the committee has seen the terms of reference, and obviously the full specification was published as part of the tender documents. I mean, that is a wide specification, and in terms of who researchers choose to talk to, that's entirely up to them. We may make some suggestions. For example, it was raised with me, would it be open to the researchers to talk to prostitutes who had exited prostitution, former prostitutes who had exited prostitution, who might have a particular view, and perfectly happy for the researchers to do that, but ultimately it's going to be their decision.
I suppose the point I'm making is, earlier you made mention of the Minister, how the Minister is minded on Clause 6. His view on Clause 6, the Department's view on Clause 6, will not in any way steer the research that will be carried out by the researcher as chosen in any way.
No, I mean, the question of the potential impact of criminalisation of paying for sexual services on reducing the levels of human trafficking in Northern Ireland is one of the areas that's highlighted that we want the research to cover. I mean, in terms of the background that we've put into the specification, what it refers to is the fact that the Minister has made a public commitment to commission research. I mean, it doesn't go into the particular views that the Minister has expressed.
And it won't?
I wouldn't be. I want this research to consider facts and to establish facts. Facts about the nature and the extent of prostitution in Northern Ireland. That then gives us a factual base onto which we can project the Nordic model, onto which we can project any other policy options and assess them. So we're really looking to the researchers to establish facts, not to try and constrain that in any way by our concerns that we've expressed.
No, I welcome that reassurance, because if there were to be those constraints, if there was to be some sort of narrowing, I think that would irreparably damage the piece of work and would actually undermine it entirely.
It is intended to be a high quality, academic, properly conducted piece of research.
Okay.
If I could just add that I think the specification demonstrates the very factual nature of the information that the department is seeking to collect. And that it is not based on any sort of wish to look at a particular ideology. It's looking at what can be found out about prostitution and the framework that is in place in Northern Ireland.
Yes, because if ideology or someone's opinion or the department's collective opinion were to come into play, then frankly it would be an opportunity missed, because the piece of work, in my opinion, would be completely without value.
Well, again, depends on the academic as well. But I think most of us actually know what the research is really about. Mr. McGuinness?
Yeah, just arising from Mr. Humphrey's questions, can we take it now that the department's position, or at least the minister's position in relation to clause 6, is now one of neutrality rather than opposition, and that the minister really is awaiting the research to be completed in order to make his mind up?
Yes. The Minister's not taking a position on the Swedish model. It's very much that he feels we need to do the research so we can see what the impacts of any policy option, be it this or another one, would have in Northern Ireland.
Thank you very much, Chair.
Okay. Ms. McCorley?
Margaret Caherly. Yeah, I welcome the progress made on the research, because I do feel it's important that we get clear evidence and relevant information on what it actually means for people who are clearly very vulnerable. Some of the most powerful testimony that we have heard has been from people who have been involved in that work. So I really think it's important to hear firsthand before you would make legislation. So what would be the context then on which you would legislate for prostitution?
Well, really in the context of having an evidence base and of having seen what is the extent of prostitution, the nature of prostitution in Northern Ireland, having seen what are the needs there, and having seen what are the best options for moving forward.
If I could add in, I think it's very important to look at, as you said, all the impacts in this period before any policy decisions could be made on the legislation that might follow. And a part of that is looking at the current law on how prostitution is regulated and how that ties in or conflicts with any desire to make the purchase of sexual services a criminal act.
If say the current proposal were to proceed, how would you feel it would impact on what already exists in law?
That is again, it's one of the areas that I think we need to look at, and once we have the research and once the policy, we're looking at the policy. The current law, as it stands, does not create a criminal offence around the exchange or of money in terms of a transaction between two consenting adults. It creates criminal offences surrounding prostitution, which, if Clause 6 were to go ahead, would still be in place. The criminal offence of soliciting in a public place would still be there, so there would still be criminal activities attached to the seller of the sexual services, and even more so in terms of sexual services in a brothel, where there would still be criminal offences attached to the seller of the sexual services in the brothel. So there are areas there which are quite complex and quite conflicting if you then criminalise the purchase of sex as well.
And it's worth noting that in Sweden, in the Swedish model, their underlying law about prostitution would differ, and it's not just the difference that's brought about by Clause 6. They wouldn't have the offence of persistently soliciting. The legislation around brothels is different. So there is a bigger picture here in terms of legislation that we want to keep in mind.
Okay. The unintended consequences that the PSNI referred to last week, what would your concerns be about unintended consequences?
Well, I think it all stems from the fact that we are dealing with extremely vulnerable people, and that's something that I know a number of those giving evidence to the committee have emphasised. And in terms of unintended consequences, therefore, the particular concern would be about anything that risked compromising people's safety when they're already vulnerable. One area which I mentioned is the impact on access to police. And last week, a couple of weeks ago, Assistant Chief Constable Harris noted that prostitutes are susceptible to crime, and that there was just a qualification in his mind about if you legislated, did that just by virtue of the general fact that you were doing more about crime and law and policing in the whole area, did that serve to put any greater barrier between police and sex workers, which he was anxious to avoid. A second area would be about pathways out of prostitution. If you took this step of Clause 6 and people wanted to exit prostitution, what is the economic impact on them and their families, and what pathways out are available? French, in considering the Nordic model, have been focusing on this quite a bit in terms of financial support and practical help. A third area would be about the impact on those who chose not to exit prostitution. If you were then dealing in a situation where clients weren't just taking the risk of discovery, but were taking a risk of criminalisation, if you've got clients who are greater risk takers, do they pose any greater threat to prostitutes themselves? And then there would be the impact around pathways into prostitution, that if people are exiting, you want to understand why people get involved in prostitution in the first place, so you can stop others simply going in and taking their place.
Chair, I read, I think it was yesterday, that there was a House of Commons committee that had some opinion in relation to this issue. I'm not aware of the actual name of the committee and so forth, but is the department aware of these?
It's the all-party parliamentary group on prostitution and the global sex trade, which is one of a number of unofficial groups which exist within Parliament across the two houses of Parliament. They have published a report with a number of recommendations, which include, interestingly, removing the soliciting offences, which we've just been talking about, include a financial assessment of the social cost of prostitution, and programmes to reduce entry into and to promote exit from prostitution. Now, ultimately, at number 9, then they come round to supporting a general offence for the purchase of sexual services. And this isn't an official body, and the Home Office hasn't made a response to the report, nor I think are we really expecting that there will be an official Home Office response, but it's certainly a report that we've been studying.
Thank you very much, Chair.
Just to pick up on one of the questions Ms McCorley asked, in terms of the elusive piece of evidence that the department needs to justify Clause 6, if he did get it, I know the Minister's already indicated to me he certainly wouldn't be legislating within this mandate. So when would it be possible for the department to bring forward legislation?
We'd have to look at the legislative programme. I mean, there will be a number of pieces of legislation that are already stacked up for this programme. It would depend on what sort of legislative change you were intending to make. If it was relatively small, I would have to discuss it with the Minister, but wouldn't necessarily rule out in this mandate. But I think we need to do the research, and we need to come to some conclusions on the way forward, and then we'll be able to assess timetable.
Okay. Mr Wells?
Just for the record, Martina Anderson, the Sinn Féin MEP for Northern Ireland, and Diane Dunn, the DUP MEP, both voted for the report in the European Parliament. I think that's a highly significant development. The two ladies of very opposing political viewpoints both supported it. Mr Johnston, have you ever met Lucy Smith or Mark McCormick?
I don't believe I have, no.
I believe you have, Mr Johnston. I believe you met them on the 31st of October 2013. I have the minute. I have the information. You met Lucy Smith and Mark McCormick on the 31st of October 2013.
Ask for your solicitor now before you answer the next question.
I'd advise you to answer that truthfully, Mr Johnson, because there's a succession of questions coming about that meeting.
I am honestly not aware of it, but if you can give me more details in case it prompts something.
You were who Lucy Smith is. This is the lady who gave us evidence.
Yes, yes.
So I mean, on her blog, she's claiming she met you. And
Different thing altogether.
and several other blogs are claiming they met you. They also met Amanda Patterson.
Here telling lies.
No, she was here when we were giving evidence, in terms of sitting in the public gallery.
So neither yourself nor Mrs. Patterson have any recollection of meeting Lucy Smith or Mark McCormick.
No.
So why would they then have posted on the 1st of November on the respective blogs that they had?
I'm not aware.
Chair, with respect, it's a bit unfair line of questioning.
Well, and for Mr Wells to continue.
Well, in the report of that meeting, Lucy Smith said to Douglas Fox, who is the leading prostitute organiser pimp in northwest of England, they hit, this is referring to your two cells, they hit the DUP more than us and will be opposing the bill. You don't recall saying any of that? So this is entirely fictitious.
Chair, on a point of order, this is hearsay. I mean, it's not something that really is appropriate to be put. If it's on a blog, and I could put anything on a blog.
Yeah.
I agree.
Well, the refusals are on the record, in terms of the denials and that will stand.
I'll not take it any further, but I have to say, if it transpired that what several people are writing was true, this would be quite a serious issue, wouldn't it?
I think, Chairman, I would want...
And if it's not true, then it's equally. I'd be the first to say that a series of people have made a false accusation that they've met you.
It started with a accusation in the first place.
I think I was off. I couldn't leave.
Yes, I mean, Chairman, if Mr Wells wants to share the text of the blog with us, we'll certainly look at it, and if there are inaccuracies, we'll seek to have them corrected.
Okay, well, we'll have to revisit that. I'd be surprised if the informant who up to now has been absolutely accurate is wrong on this issue. I'd be very surprised. Now, why are they reducing the offending? Why is reducing the offending unit not here today?
That leaves the record of this meeting sounding very difficult for me. Those are remarks which I would wish to disassociate myself from. I find it very uncomfortable to suggest that somebody saying that their source has always been accurate up to now.
Has been.
We've had a clear denial from the parties concerned that they have not had the conversation that was outlined, and I think we should leave the matter there, and I certainly feel extremely uncomfortable by being associated with those remarks.
Assuming Mr Wesley is leaving it at that point.
Yes, I mean, we will check our sources in this, unless there's another Gareth and
damage has
Amanda
already
working
been
in this
done, Chair.
office. This information has come from a source that also gave me the information on another secret email which I quoted at a previous Justice Committee meeting, which was entirely accurate. Entirely accurate. So that's all. But if I accept your point, but Mr Johnson, you're saying you didn't.
I'm saying
you've never met anybody of that description ever.
No.
Right. Well, I accept that. But it doesn't. I have still other questions to ask you. I can assure you. Why is the reducing the offending unit not here today?
Well, we're only allowed 4 people at the table.
And why was the only unit who has been directly involved in this not one of the 4 here today?
Well, we have been having discussions outside of this meeting with the reducing unit, and indeed there was a meeting, Amanda, 2 weeks ago, when all 3 of our divisions were represented.
But why are they not here today?
I think that's largely because what we're looking at today is a change to the criminal law, which is the responsibility of the division that I work for.
I quoted from some of the material at the meeting 2 weeks ago. There's quite clearly a split between the Criminal Justice Unit and the Reducing Offending Unit. The Reducing Offending Unit is very clear in its view on prostitution, the nature of it, the vulnerability of the part in it, whilst the Criminal Justice Unit seem to have a rather different view. Are the DOJ split down the middle on this issue?
No, and I don't believe there is a different view. There are different parts of the department that have specific responsibilities. One of the responsibilities of the Reducing Offending Division is in supporting people who have been caught up in offending. One of their responsibilities was the production of the women's strategy. Flowing from all of that, there are certain actions that are being taken, including guidance for the criminal justice bodies in dealing with people whom agencies may come across who are involved in prostitution. I think that's a very positive development, and it complements rather than being in conflict with the discussions that we're having today.
Well, if it complements, given the fact that I haven't read the report from the Reducing Offending Unit, I cannot see how that complements your view as articulated today. I just cannot see that. And they're the folk at the coalface, and they're the folk that are advising, and they are being guided by the Department of Justice. They're being guided.
Chairman, I have to refute that. There is action being taken across different parts of the department, and as I say, it all aims to complement each other, and I think it would be very regrettable if the good work that the Reducing Offending Division is doing, including in this new guidance, if it were held back in any way.
Right. The Minister issued a press release on the 27th of January 2011 which spoke about the Department wishing to help people to leave prostitution. How many people have the Department helped out of prostitution?
The responsibility there would lie with the particular agencies, both criminal justice and health agencies that are involved, and I don't have particular statistics.
Has there been anybody helped out of prostitution by any of those agencies?
As I say, the responsibility lies with the agencies rather than with the department centrally, and that's something I would have to check.
And, yes, it would be very useful if you could come back to us on that. After the first hearing here, Mrs. Laura Lee made a complaint to the Minister of Justice about the questions I and the Chair asked her. Where did that complaint go to?
I am a little uneasy, Chair, with answering questions about individuals who may or may not have written to the Minister. I mean, I'm just conscious that there are data protection issues.
She told the press that she'd made a complaint to the Minister. and your department received that?
Maybe, Chairman, I could deal in general. If we were to receive a complaint from someone about something which had happened in the committee, that is not, the department is not the appropriate person to be receiving that complaint. I think really all we would be able to do would be to point them in the right direction.
And that's all you did?
As I say, I don't want to get into individual cases because I think there are data protection implications, but in general terms, if we were to get a complaint, that is what we would do. We would
and
point
there'd be
them
no
to the
question of
appropriate
you
agencies.
assisting the complainant with their case, before that was sent on to standards and privileges?
No.
You'd be surprised if the complainant had a different view?
Yes.
Right. But you're giving me a categorical assurance that it was simply asked, you would act as a postbox and you wouldn't assist the complainant?
We, as a department, receive a great many complaints about the actions of various independent agencies, some of which have no connection with the department. And there are fairly settled forms of correspondence which go back in those cases, which point people to the appropriate agency to deal with those complaints.
I think there's a second letter to go to DOJ about that. There's a constant reference to the Swedish model. How many times have you been to Sweden, Mr. Johnson and Mrs. Patterson?
The Minister intends to visit Sweden in the very near future, and there'll be an official going with them.
Right. Well, could I suggest that there's at least more than one official goes with them? Because I think it's vital that you receive the maximum amount of information about the Swedish model.
Well, we'll discuss that with the Minister.
And when you say within the near future, how close? Before Easter? St. Patrick's Day?
Yes, before Easter.
Right. Well, that's good, because I think, to some extent, you're the only player in this who hasn't been to Sweden. And I think you need to go. Now, the Minister was in Westminster this week giving evidence on human trafficking. Now, why was he there?
I can answer. I was with the Minister. He was invited by the chair of the group, which is a joint committee of the Houses of Parliament, Frank Field, to attend to give evidence on the modern slavery bill, which the Home Secretary is taking through Parliament.
Right, okay. But he hasn't given that. Has he released the draft of what he said? Is that in the public domain?
I believe it was recorded and will be available in the same way as the evidence today.
Okay. Now, the Swedes, the Icelanders, the Norwegians, now the French, the European Parliament, Martina Anderson, Diane Dodds, and now the all-party group on prostitution, Westminster, have all came to the same conclusion on the equivalent of Clause 6. Why are they all wrong and the department is right?
We're not saying at all that they're all wrong, but in terms of those different countries that you've mentioned, they have reached a conclusion on the right way forward in the particular circumstances that they're in. One could equally mention countries, Germany, Canada, who have reached extremely different conclusions. We are not, and I repeat this, we're not taking a position on the Swedish model at this stage. We're not ruling it in, we're not ruling it out, but we believe that we need the research in order to understand fully the impacts that it would have in Northern Ireland.
Thank you, Mr. Chairman. Thank you. Mr. Alderson.
Thank you, Chair. Thank you for coming along today. Mr. Wells has touched on a number of points here. Can I just follow up on a couple of points? He had a long list there who were actually in support of Clause 6. The Northern Ireland Human Rights Commission stated in their evidence to us that they welcomed the principle of Clause 6 and did not believe that it was incompatible with human rights standards. Considering that your department and your opposition to the introduction of Clause 6, do you believe that they are wrong?
The Human Rights Commission have expressed their views, and they've expressed those very much in the terms of the protection of vulnerable people. Now, obviously, that is a criterion that we equally are keen to ensure is satisfied. But in terms of whether they're right or wrong, well, let us do the research and come up with a settled policy position.
In light of your comments there, would you not have thought it would have been wise to maybe have made contact and sought advice from the Human Rights Commission in respect of this clause?
Yeah, I think we have met with the Human Rights Commission.
Have met, and you've what Gareth was talking about there, have in relation to vulnerable adults and things like that, have you discussed these issues?
Well, I think the response is what we're giving here, that the Minister hasn't yet reached a position and wants us to undertake further research.
But I mean, I would certainly expect and be open that in the course of moving forward, we would want to keep in touch with the Commission and be informed by anything further. We have their response, but be informed by anything further that they would want to see.
You'd agree the Commission would be someone who you should maybe have a good listening ear?
I'm quite happy to accept that, yes.
Very pleased that you understand that.
This is all wrote down.
So in this particular issue,
Well, this particular is, I know, right one day we're wrong, and
She's just selected here, Mr. Chairman, is it?
well,
careful who you call for a witness.
can I also ask, well, if we're getting support for Clause 6, we have to listen to everyone who would support it. And my colleague, Mr. Wells, has given a long list of people. I think the greatest opposition is probably coming from the department here. And certainly, I think we have to take on board all those people who will support those victims. And that's where I'm coming from in this particular one.
And the committee's report will be certainly a very significant document in terms of the ongoing consideration of the department.
Picking up on the we've talked a number of times about the Swedish model, and you have clarified to my colleague Mr. Wells that officials have made some contact. Did I pick up that with
Yes,
yes. Already made that, and the Minister is taking himself off quite soon. We've clarified that for Easter.
Yes.
To go to Sweden. Gareth, he also did mention the fact that the Minister was somewhat neutral in this. Is that right? What I picked up in his opinions at the moment?
Yes, he's not ruling it out or in.
So he hasn't set his face against the Swedish model?
No.
He's going with a clear mind, with an open mind to Sweden on this one.
He's certainly going very keen to speak to people at the front line and to speak to Swedish commentators and to see for himself the evidence and to find out the range of views.
Why I asked that question is in the lead-up and all the discussions that has taken place, you know, someone's mind or views could be tainted before they go somewhere, you know what I mean? And I do hope that when the Minister goes there, that he does have an open mind. I know his colleagues sitting here, I hope that he goes with an open mind and comes back with the facts that has been well presented by others.
But I can assure Mr. Anderson that getting at facts is very much what the Minister wants to do.
Yes, I think that's what it should be. Okay, thank you. Thank you, Chair.
Mr. Elliott.
Chair, thanks very much for the presentation. Two queries or questions. I know at this stage the Department are opposing Clause 6 in this form, and it has highlighted on Mr. Wells a number of groups and organisations that are in support of Clause 6, and I know, coming from a fairly objective position myself, there are a huge number that are both opposing it and a huge number supporting it. So, you know, that's an issue that we have to get our head around as well and establish who's right and who's wrong. What I'm wondering, are there any amendments that you within the department would see that would actually help Clause 6 or make it more practical to implement or better to implement as opposed to a total rejection?
I think at this stage, given what we've said about the importance of research and about having an evidence map on which to project any policy, at this stage our position would be very much that we should move ahead without clause 6 and then come back to all these issues in the light of the research.
Okay. Quite a second question that answers that quite clearly. The second question is around the Swedish model, and again we've heard quite a bit about the Swedish model on committee. And even today it's been referred to. What do you see the Swedish model, either in positives or negatives, bringing to the legislation? You see it as a help or a hindrance in this case?
Well, as I say, I think really we have an open mind. And we want to do the research. I mean, we're conscious, as the discussion has been ongoing on clause 6, that there have been both pros and cons expressed about the Swedish model, and we've seen the Hansards of the evidence that's been presented to the committee, and we're aware of others who have commented on the Nordic model, including in the reports which have been mentioned. So, really conscious of.
I think, Gareth, we're all well aware here what others have said about it.
Yes.
But I'm interested in what you said about it.
Yeah. Well, I mean, really where we're at is wanting to get more information about what would be the impacts, maybe the unintended impacts, and they are really, as I was setting them out to Ms McCauley, around impacts on access to police, and that was something that the police raised a couple of weeks ago, about economic impacts and how people could be enabled to exit prostitution, about the impact on those who chose not to exit, about how pathways into prostitution would need to be affected. And also just about the fact that clause 6, or the equivalent, doesn't sit on its own in the Swedish situation, but there are other differences in the law which we need to be clear on, and whose impact we need to assess.
Sorry, just to expand on that, Chair, a wee bit if you can. When you say clause 6 doesn't sit on its own in the Swedish model, are you saying it's built into a wider piece of legislation?
Yes.
In that respect?
Yes.
Yeah.
And the legal framework isn't the same in Northern Ireland as it is in Sweden, and there are also issues to do with that. And what I was saying earlier about the current criminal law around the offences to do with prostitution, and where does it sit with that, and also to do with the enforcement issues which the police I think gave you an evidence when they were here, in terms of the differences in how the Swedish police might approach that rather than how it could be approached here.
Thank you. Thanks, Chair.
If the clause 6 was to go through, would it be open for the department to bring forward the legislation after the research and obviously make some amendments if the consequences, as people say, unintended consequences, if that was negative? Would we be able to amend it at a later stage through a proposal from the department?
We don't believe that that's the right approach. I mean, certainly often when I'm sitting here and proposing various pieces of legislation, I'm being asked about what are the impacts, what are the quality impacts, what are the practical impacts, and the department's position would be very much that it would be important to understand those and take account of those before going into legislation.
I understand you think it may not be the best approach, but for members who think current framework doesn't work or isn't effective enough, we've got evidence and we're satisfied that the evidence warrants a change and we legislate for that change. However, if the unintended consequences, some of are negative, can we amend that by way of legislation through a bill that the department could bring to the Assembly?
I'd rather that we went into this knowing more about what the consequences were going to be and dealing with them up front, rather than having to come in behind with some very rushed piece of legislation to try and deal with problems that only been identified.
Well, it's not rushed in the sense of someone's tagging on an amendment to a bill. It's a private member's bill that's been in the ether for well over a year. It's going through the proper scrutiny processes that is required of legislation, so I wouldn't put this into the category of rushed.
Sorry, Chairman. No, what I meant was that you might have to rush in with amending legislation to deal with the problems.
Okay, no, then I picked up on that, so apologies, wrong. Okay, I'm going to assume that the answer to it in a purely legalistic sense is yes, we can legislate for this, and yes, you can amend. That's a simple procedural thing that can be done. It may not be the approach that you think is necessarily the best, but for members who have to decide it, I'm going to assume the answer to that is yes. Mr. McCartney?
Thank you very much, Chair. I suppose picking up on your last point, in terms of when you spoke to Lord Morrow, have you agreed a timeline as to how this should be taken forward in the future?
We've sent instructions to Council on our amendments, and we're hoping to get those back as soon as we can to share with Lord Morrow and indeed the committee. We don't have a specific timescale for that because we're in the hands of Council, who have many bills, etc., to manage. But certainly, as soon as we get them, we'll be sharing them with Lord Morrow and indeed with the committee. We are alive to the fact that time is of the essence.
Yeah.
And the other element would be, and if it were possible to table further amendments on the back of our consultation, subject to that, then we have discussed that with Lord Morrow, and the earliest we believe we would be in a position to do that would be if consideration stage were to be towards the end of September.
Yeah.
So we've discussed that with Lord Morrow, and he has indicated that he would be content to defer in principle to that time.
And have you discussed the timeline for the proposed research, which is the end of October? No. So given the Chair's point of, if there's something in the research which will inform us, that the gap seems to be, is there anything that you can do to bring the outcome of the research earlier, so you don't end up in a situation which the Chair talks about, that you do this piece of work, something comes out of the academic research, you say, well, just people say, well, I would change my mind on that aspect of it, but we have no provision passing you change the import.
It's a substantial piece of research. It's going to involve talking to a lot of people, including people who are personally involved, and I don't think we can telescope the timetables anymore. In terms of Lord Morrow's awareness, I'm not aware that we have communicated with him specifically on the timescale for the research, but the Minister has answered Assembly questions on it, so the information's in the public domain.
No, but I mean, you're saying today that Lord Morrow has, I suppose, showed patience from his point of view to say that he's willing to do it at the end of September. No, the end of October doesn't seem to be too much of a push out. I mean, that's why I'm asking if you discuss that particular aspect of it.
I think then there would be too much coming out of that research to immediately say that we could make a decision within a short period of time. Because we'd have to consider what has come out of that research, and there may be recommendations that would involve other people and having to consult with other people, and to I don't think it would just work.
So in the piece of, when you receive the academic research, will that be a closed document for a period, or will you release that so as even to inform the committee for the next stage?
We would want to release that as soon as we could.
Okay.
Yes.
And is the terms of reference set before the tender, or is it once the tender's?
No, it's set before the tender. That's the basis on which you tender.
And is the terms of reference open, or are they closed?
Well, yes, we sent the terms of reference to the committee, as far as I know. It's not available any longer on the central procurement website because it comes off at the end of the period. But we have sent it to you in the past.
Okay. Thank you very much.
Thank you. In terms of the proposed amendments the department's bringing forward, we're obviously hoping to do clause by clause on the 20th of March, so will you have them with us by that point?
We have our instructions with council, and the honest answer is I can't tell you today. We'll talk to council again and see what timescale they're able to work to. They're under a lot of pressure, and if we with your permission, let the clerk know what the position is in that.
Okay, no, because that's we're obviously need to complete our report, so we'll be going through the legislation. We'll only have a couple of weeks really to do that, so if we can have those as soon as possible, that'll be appreciated. Let me formally thank you, and Julie, you have persevered with the cough, so thank you for coming to the committee.
Chair, may I just come back for one moment? If it might help the committee, one of the areas Mr Wells raised was around the work the department's doing around prostitution, and I think we didn't express all the areas that we're working on, which there are many of, and I just want to put on the record we are working in a number of areas, and if it would help the committee we could possibly send you a note just setting out the initiatives that we're taking within the department. They cut across a number of different divisions. Community safety units do domestic and sexual violence. Gareth's side do the legislation reducing offending at our side, and I think I wouldn't want you to leave today thinking the answer we gave showed there was no work going on. There's a great deal of work, and I'd like to put that before the committee.
That would be appreciated. Thank you all very much. Much appreciated. Okay, members, we go to the next item, which is an oral evidence session with the Attorney General on the bill. Pages 53 to 54 of your meeting folder has the relevant information. And this was an area we picked up on the 13th of February, and we asked for the Attorney to come to the meeting. So let me welcome the Attorney General for Northern Ireland, Mr John Larkin QC, to the meeting, and as usual it'll be recorded by Hansard and published in due course. So Mr Larkin, you're very welcome, and thank you for making yourself available to the committee to address some of the issues that members had. So I'll hand over to yourself at this stage, and then members will have some questions.
Thank you very much, Chair. Once again, it's a pleasure to be before the committee as it engages in its important work of legislative scrutiny. What I propose to do, and I suspect it'll not be entirely satisfactory, is go through the clauses one by one and make some quite technical observations, by and large, on each of them. Then, inevitably, there'll be the questions from committee members. And then I thought it might be useful, if this would be of assistance to the committee, if I were then to set out views in writing as a result both of my original thoughts and then any adjustments in that arise from the views of the committee. I thought it might be preferable to do that rather than sort of submit a short paper now when some of the points that committee members might make might cause readjustment. So, if that's satisfactory, I'll go through the clauses one by one. Clause 1, I understand, may have to be adjusted in terms of any changes that take place in terms of the framework or the Department's current consultation, to which allusion has already been made. So I'll say nothing more about that. Clause 2, as members will know, deals with the irrelevance of consent. Now, there's nothing really wrong with the clause, but I simply ask the question, what does it do? And I'm not sure that it does anything, because within existing criminal law, consent is vitiated by the very features that are identified in A to E. So if one threatens someone and obtains consent as a result of that, as a matter of common law, that consent is vitiated. So I'm not sure what it does, and usually if it is not necessary to enact any particular provision, then in my view it's necessary not to enact it. So I leave that with the committee. The aggravating features set out in Clause 3, again, no obstacle to the legislature setting out a series of aggravating features. These are not inconsistent with judicial discretion in sentencing, so I have no observations of substance to make in relation to Clause 3. Clause 4 has given rise to a little controversy. Clause 4 is, again, a perfectly proper device if the legislature is satisfied as to its policy. And this is not a hard minimum sentence model, because any judge who considers that injustice will arise in a particular case by the imposition of the statutory minimum will be free to depart from that predictive statutory minimum. May I make two technical observations? The first is that it should be made clear that the custodial sentence is only going to be applied to a person of 18 years or above. Secondly, it may be thought appropriate to insert immediate before custodial, because I imagine that it chimes with the policy intention, because as it's drafted at present, it would be open to a court to impose a suspended sentence. A more general observation in relation to Clause 4 would be that if one is allowing, and in my view it's quite a proper thing because it preserves judicial discretion, to allow for an exceptionality condition, then one might want to require some statement of reasons as to why a judge in any particular case considers that the case is exceptional. In relation to Clause 5...
just on 4, if I can... So you don't regard Clause 4 as being a mandatory minimum? That exceptionality then will still allow judicial discretion?
Let's assume, for the sake of argument, that someone has been involved in human trafficking in circumstances which don't quite amount or don't quite give rise to a defence of duress, but it's clear that someone's been a very minor cog in the wheel, that they themselves have suffered as a part of that dreadful process, and a judge considers that it would be the height of injustice to impose the minimum, the predictive minimum that's set out in Clause 4. No judge would ever be prevented from imposing the sentence that he or she thought was just. The issue, I suppose, is one might want to know what the reason was, and it might be worthwhile for the Assembly to consider inserting a provision that required the statement of reasons for believing the exceptionality condition was met.
Okay, thank you.
Clause 5, this may of course become redundant, I understand, in view of the Department's consultation, so I don't make any observations on it just now, but I am of course obviously happy to make any observations in the light of it when it looks as if that clause has bedded down. And now we come to Clause 6. The committee will be relieved to hear, naturally, that the policy wisdom of this is not a matter for me, that's a matter for the Assembly. But there are some specific technical comments that I think I should make. Firstly, in relation to competence, I note that the PPS in the evidence that 3 PPS officials gave to the committee suggested that there may be issues around Articles 8, 10 and 17 of the European Convention on Human Rights. Article 8 is engaged, and subject to the points that I make shortly, I don't think that this provision would infringe Article 8. I don't see that Articles 10, which deals with freedom of expression, nor Article 17, which deals with abusive rights, are likely to be engaged, far less breached by this provision. Turning to the technical issues, I think the definition of payment is too wide. Payment, members will be aware, means any financial advantage, including the discharge of an obligation to pay or the provision of goods or services, including sexual services, gratuitously or at a discount. Now, one of the policy aspects, of course, which is, I think, been pointed out by the PPS, is this may include lap dancing, that be included, and things of that nature. That's a policy call for the committee and for the Assembly. But the reference to sexual services troubles me, because it strikes me that it's possible that this will mean that the mutual exchange between two persons of sexual services, if I do X, will you do Z, would be caught by this provision, and I don't think that's the policy intention of those sponsoring the bill. So I think it would be safe to remove that. I think it would be important to remove that from Clause 6.
This is the reference to sexual services.
Sexual services. So that's when we take out the words are in brackets in what would be for the substituted 46A3. So in 64A3 in the third line, I would suggest taking out including sexual services, because of the, strikes me, impermissible breadth that that would lead to. Now, one can see how it's happened, because that definition is, of course, taken from clause the definition provision in the 2008 order, but that in itself, of course, refers back to different offences, and it may be entirely appropriate in the context of those offences, but it strikes me as not being appropriate in the context of this offence. Incidentally, members may wish to notice, and this is a point which has only occurred to me relatively recently, that one of the reasons for the apparent ineffectiveness of the old 64A may be the fact that it relies on the concept of prostitute, and prostitute requires an additional evidential hurdle, because prostitute is defined in Article 58 of the 2008 order as someone who has offered sexual services on one occasion, and I think the context means that means one other occasion, apart from that giving rise to the particular investigation or the charge that is then before the courts. So I think it's technically neat that this definition avoids the previous approach to prostitute, and indeed it might be something that the committee might wish to consider, because although the definition of prostitute in the 2008 order, it represents a narrowing and a modernisation and a refinement of the old common law approach, the idea that people are, one might say, stigmatised as prostitutes henceforward strikes me as undesirable. I mean, one doesn't call someone a thief because on one occasion they have stolen a bar of chocolate. So I think we shouldn't, if we can avoid it, stigmatise individuals who may have got caught up in offending for all kinds of reasons. And the final technical issue in relation to Clause 6 relates to some uncertainty over the penalty. That's provided for in 64A2. Person A is guilty of an offence under this article on summary conviction to a fine not exceeding level 3 on the standard scale, to imprisonment for a term not exceeding 1 year, or a fine not exceeding the statutory maximum, or both. Now, it's not clear whether or not it's intended that this offence should be triable summarily only or on indictment, and that should be made clear. I suspect that it may be intended to be triable summarily only, in which case one would have in 2, person A guilty of an offence under this article is liable on summary conviction, A, to a fine not exceeding level 3 on the standard scale, B, to imprisonment for a term not exceeding 1 year. But in that case, if that is the policy intention, one would then delete the words or a fine not exceeding the statutory maximum, or both. And I suppose the other point, which I understand from the police evidence to have arisen in the context of this clause, is in relation to the time limit. If the offence is triable summarily only, there is a presumptive time limit of 6 months contained in the Magistrates' Court's order. it may be thought desirable to make specific provision extending that time limit if it is thought that it's best to keep this a summary-only offence. And as I mentioned, the approach to the definition of payment comes from the 2008 order, and it might be thought desirable to make sure that there is a match between the other parts of the 2008 order and this provision, and I'm not sure that there is entirely. Again, that's capable of ready amendment should that be thought desirable. Moving on to Clause 7, I understand that...
Sorry, Mr Duggan. In terms of those technical issues, if they were addressed, I'm assuming you've read some of the issues the PPS said about prosecuting cases on Clause 6.
Yes.
Would that overcome the difficulties that they had highlighted to the committee?
I think it would, and I think obviously this feeds into the policy approach, but as I understood the police evidence, it seemed to be that although this wouldn't be the easiest offence in the world to prosecute, they saw it as a useful addition to the police armoury. So, and it would, in response to your specific question, Chairman, I think address some of the PPS concerns.
Okay, thank you.
Clause 7. I understand that Clause 7.1 will go, if I've understood or been correctly informed as to the sponsor's intentions. What I would suggest is that 7 should go in its entirety, and that is 7.2 and 7.3, because they are statements of existing legal reality. And if you say something again, it will be assumed as a matter of statutory construction that you're saying something slightly different, and that could give rise to problems in the future. So, for example, it is simply true to say that the investigation or prosecution of any offence shall not be dependent upon the reporting or accusation by a victim wherever the offence takes place. I'll give the most stark example of that. Murder victims don't normally report the offences that have just been committed on them. Similarly, if a victim has withdrawn his or her statement, happily, as I think the committee will be aware, that in cases of domestic violence, the PPS and the PSNI very properly do proceed very often, even though the complaint has been withdrawn. So I don't think that Clause 7 adds anything, because it doesn't, back to the principle of if it's not necessary to legislate, then it's usually necessary not to legislate. So I think nothing's added by Clause 7. Clause 8 goes much further than the directive. The directive simply requires the UK to be in a position not to prosecute. Well, the prosecuting authorities in the UK have always been in a position not to prosecute. They've always had a discretion not to prosecute, particularly where the public interest so requires. The PPS have their own internal guidance on this, and the committee will perhaps recall my guidance to the PPS, which I hope to lay shortly, which includes specific provision for victims of trafficking. So I think Clause 8 goes much too far, and at present, for example, would operate to bar the prosecution of the trafficked professional assassin.
Is there any other way that we can amend this that still seeks to do what obviously Lord Morrow wants to do? But
well, obviously the committee will no doubt hear again from Lord Morrow, but I get the sense, it may be a wrong sense, but that with the existing guidance that's in place, that may well satisfy Lord Morrow's concerns. Certainly I would encourage him and the committee to look specifically at the guidance that I have in place, and hope to lay shortly dealing, among other things, with this very issue. Now, that probably deals with the great bulk of the concerns or the technical issues, because as one moves towards to Part 2 and Part 4, 3, 4 and 5 of the bill, one is dealing with issues that I understand are still subject to quite a bit of potential fluctuation. I'm happy to deal with any specific questions. The only issue that I'll touch on is clause 19 and 19.2 in particular. It strikes me that if the policy decision is taken that this is a good bill, that one might want to actually make straightforward provisions within the bill itself for its own commencement. So, for example, effective on consent or effective after a certain period of months, because certainly if the previous evidence session is anything to go by, there is still some remaining gap between the bill sponsor and the department, and it may place the department in an invidious position if it is having to make a decision about commencement with respect to legislation that it may not be entirely happy about.
That could be put in effective on giving royal assent.
Yes.
Okay, that's been very helpful, Mr. Larkin. Members, any other questions, Ms. McCorley?
I maybe just didn't pick up quite right. Could you just clarify again what you were saying about the definition in clause 6?
Yes, clause 6 at present strikes me as too broad, because the reference to including sexual services in 64A3 could mean, obviously it doesn't want to be indelicate, but that there could be an exchange. If you do X, I'll do Z. X and Z obviously being activities of a sexual nature, and that would appear to be caught by this provision. And plainly that's not the intention, as I understand it, of the sponsor.
So you mean it's too broad? It could be like phone calls?
Well, it's not so much that's a pure policy call. I think lap dancing, for example, plainly seems to come within that. Now, if one thinks that that's appropriately penalised, and it's not for me to express a view on that, then that's fine. My point is this goes a little further. This means that two persons potentially engaging in entirely mutual and uncommercial sexual exchanges might potentially be caught by that.
Whether, as in no transaction of money?
Yes, none whatsoever, and nor any suggestion of exploitation. So, for example, one could have someone who, in absolute economic desperation, and someone who is in a position to offer employment, and again, in policy terms, that can be viewed as highly undesirable. Or not, variety of views undoubtedly about that. But this is the situation where there's no commercial or exploitative issue around. It's simply two people engaging in sexual transactions of an entirely non-pecuniary nature, non-commercial nature, I emphasise. And if it is explicitly sort of set out, you do this, I do that, then one could come within this clause.
Because certainly what I want to make sure I can still achieve is, even if it's the consenting adult, what payment is involved.
Yes. Well, removal of the bracketed words in 64A3 will in no way affect the policy efficacy of what I think Lord Morrow is designed to do. This strikes me as an entirely accidental byproduct, and one which is not, on reflection, I suspect, desired.
Just briefly, Chair, and thank you for your explanation. Has been very helpful. Just going again on that area, the nature of a commercial transaction, could that, for example, be a box of chocolates or a bunch of flowers?
Well, if it is, again, moving into very delicate territory here, I don't know of anyone. I think that people may offer extravagant gifts with the hope of certain outcomes, but I've never in my life come across anybody, even at third or fourth hand, who has been as crassly explicit as to say, well, if I were to provide you with a nice bunch of flowers.
But really what I'm trying to get is, where do you draw the line between something as innocuous, perhaps, as a bunch of flowers and a box of chocolates, and, for example, a ring, a diamond stone, a bottle of champagne,
Well, again, you see, I think if one considers
Where do you draw that line?
well, yes, taking it
When
out
does it
with,
become a commercial transaction?
well, it's commercial if it's explicit. I think that's the quick answer to that. But I think if one looks at an offence such as careless driving without due care and attention, it's an offence that's committed on a massive scale. If every instance of that offence was detected and processed by the police and the courts would, I hazard, do nothing else. And it may be that around the edges, if, for example, back to take Mr. Dixon's example, that you have some grotesque employer who says there's a promotion coming up. If you sleep with me, you get the promotion. And well, in one sense, I think many people may think in a policy context, if someone exploits, engages in that crassly exploitative behaviour, that might well be properly penalised. The person who, on the other hand, takes his girlfriend or his boyfriend away for a lavish weekend with certain hopes doesn't fall, I think, within the clause.
So, although if somebody, okay, but you could reverse the employment situation, and the person maybe offering the employer something.
Yes.
For promotion as well.
Yes.
And then you extrapolate that onto the street or onto much more casual relationships, people who don't know each other, people who meet on the internet or by phone. They're a bit like all those 32, 33 mile an hour speeders.
They are, but the reality is that those are the cases. I mean, the police have, I think, said that the clause is capable of being policed, not without its difficulty, but those are the examples of behaviour which, even if at the more extreme level they were technically caught, would never, I think, come within the purview of any serious decision to prosecute.
And therefore, I mean, sorry, Chair, to carry this on in relation to the sort of line of questioning that Mr. Wells has taken up on occasions, where does that leave the very clever, manipulative people that are out there that are actually providing good services that we're trying to legislate against? Where does that leave them in being creative and finding the way around all of this?
Well, I think that's where the clause is helpful, because the clause is broad. So it will be difficult for such persons to avoid it. Of course, the interesting thing is this model doesn't so much target them. There are other provisions, of course, within the 2008 order, as you know, which do. This looks at supply, and at the other, sorry, I beg your pardon, it looks at demand, not at supply. And that, certainly in this jurisdiction, is a new approach, but an approach, as members will be aware, that's been tried in the Nordic countries and France.
And where does that leave the person who will inevitably claim that they are the innocent party, but nevertheless they may have paid for something, and the payment might be that bottle of champagne or the box of chocolates?
Well,
is that their defence?
Well, I think that the first offence is that say, well, look, the offence hasn't actually occurred. I bought...
Chocolates might have been consumed.
Oh, no, they will have been consumed. I'm very surprised if they weren't. The chocolates and the champagne will have been consumed. But the question is, was there an explicit, as it were, contractual arrangement? And I think in the absence of that, the mere jostling around of hopes and expectations, I think, wouldn't suffice to bring this within.
Because you see, what we actually saw when we went to Sweden in terms of the evidence that was shown was that there was actually surveillance to the point of where the police were satisfied that sexual activity had actually happened inside the room, and that was done by listening to the conversation and then ultimately to particular noises which they had decided gave them sufficient evidence to open the door.
Well, I suspect police much better equipped to speak about this than I am, but I suspect that the major use of this will be largely in relation to a package of offences. So people may well be arrested in particular contexts. Evidence may come forward, or if it's thought that there's a particular problem, and of course policing policy ebbs and flows on a variety of issues, but if it's thought that there's a particular problem about this, then you would have the kind of approach that's taken in North American cities where they don't have this legislation, where they use decoy police officers and people are arrested by virtue of the act of solicitation and charged with the inchoate offence rather than the complete offence.
Thank you, Chair. Mr. Humphrey.
Yeah, thank you very much for your presentation today, Attorney General. Can I just ask you one question? Relating to the Northern Ireland Human Rights Commission, you'll be aware that they gave evidence to this committee and they welcomed the principle of Clause 6. And they believe that it was not incompatible with human rights standards. Do you share their view?
I do. I hope I've said as much. Yes, I do.
Okay.
Mr. McCartney.
It's in relation to the clause 4. The idea of exceptionality, does that not undermine, like that sort of concept of a minimum sentence? Pleading guilty early could be exceptionality.
Well, the committee will be aware in a different context, for example, that of legal aid and the decision of magistrates to grant certificates for true counsel, that technically the certification for true counsel should occur only either in a murder case or in a case exceptionally the interests of justice so require, and yet one knows that certificates of true counsel were occurring in cases that, on the face of things, appeared to be far from exceptional. That's why I make the suggestion that a useful addition may be a requirement for reasons to be given by the judge who considers that in any particular case the exceptionality condition is met.
Yeah, but I mean, you could see the scenario at the end of every trial when a person's found guilty, then there will be perhaps a long discussion about this is an exceptional case and here's the reason why. I'm just wondering, is it not just better that the clause reads it's a minimum sentence, or it's not a minimum sentence? That's what I would be.
Well, I think there are arguments about the potentially excessive rigidity of a minimum sentence regime, and this bridges the gap between ensuring that the legislature is able to impose its views legitimately on the judicial branch of government, at the same time ensuring that injustice doesn't occur because of some truly, let's use the word exceptional case, which merits a different approach. But that's why I think that one further preserves the harmony by insisting upon a provision which requires reasons to be given for the exceptionality.
And in your opinion, before custodial, the word immediate, because you get a custodial sentence, but it could be suspended.
Absolutely.
Thank you.
Okay. Any other members have any questions?
Just one point, Chair. Just in relation to Clause 8, would one way of addressing what Lord Morrow is intending to address, which I assume is to try and give as wide as possible immunity to victims, genuine victims of human trafficking, would not the better way be simply to look at the code for prosecutors and see if that is reflective of the necessary flexibility that prosecutor would have such circumstances?
Well, I agree, and I think I've said that, to which I'd add the section of guidance that I've already circulated to the committee, because...
As Attorney General?
Yes.
Yes. Thank you very much, Attorney.
Other members on this issue. Attorney General, when I have you in front of me, some members have been speaking to me about the issue to do with the on-the-runs, and I'll get to that later in the item, later in the business of the committee. But a number of people have been obviously asking about you as Attorney General, because there's been a lot of reference to an Attorney General being involved in this process. what has your involvement been in the scheme?
Well, I've always wanted to have an opportunity of saying this, Chair, not me, Gov. The references to Attorney General that you will have come across do not refer to me. I've had no part in the devising or administration of any scheme of that nature.
Okay, you have a consultative role with the PPS. Has that ever been engaged?
Well, the consultative role, and I've spoken to the committee about this, is a rather curious one in the sense that the Director and I have a statutory obligation to, or rather a statutory discretion, to consult one another on matters for which the Attorney is responsible to the Assembly, or matters for which the Attorney is responsible, but I don't have responsibilities. Once I've appointed a Director and Deputy Director, once I'm consulted in relation to the content of the Code for Prosecutors, to which Mr McGuinness has lately alluded, and tiny matters of that nature, I don't have to be consulted, and I certainly haven't been consulted in relation to the operation of this scheme.
Okay, well, I'm not going to ask you questions about your view of the legality of the scheme pre and post devolution, because I know some members have said to me they want to seek your opinion on that, but I don't want to bounce that on you at this stage, but we may well wish to engage your services.
Well, firstly, I'm very grateful for your forbearance, Chairman, in relation to that. And as you know, it's a matter in which I may be asked to advise Executive Minister, or indeed, as you say, Chairman, it's a matter in which I may be asked for advice by the committee. And in those circumstances, it wouldn't be happy to informally offer a view at this stage. And to which I would add that there are factual issues on which I'm simply not cited. So that too, I think, would militate against the expression of even a tentative view at this stage.
Okay. Okay, well, Mr Duggan, can I thank you for coming to the committee?
Yeah, a pleasure as always, Chairman. Thank you very much. Thank you.
Okay, members, moving to the next item on the agenda is the Building Society Special Administration Rules 2014 and the Stat Rule around Building Society Insolvency Rules. And I'll also take agenda item 8 as well, which relate to two statutory rules together. Pages 56 to 141 of the meeting folder has the relevant papers. At its meetings on the 8th of December 2011 and the 12th of January 2012, the committee considered and agreed that it was content with proposals for the Department of Justice for two statutory rules to make provision for procedures to be followed if a building society is undergoing the Building Society Insolvency Procedure or the Building Society Special Administration Procedure. Purposes of the statutory rules is to replicate in Northern Ireland the protections available in England and Wales. Statutory rules were subject to negative resolution procedure. They were laid by the Department of Justice in typescript on the 19th of February to avoid breaking the 21-day rule, and will come into operation on the 13th of March 2014. There have been no changes to the policy content since the SL1s were submitted to the committee, and the Assembly Examiner of Statutory Rules has confirmed that he has no issues to raise with regard to the technical aspects of the rules. So if members are content, then let me formally put the questions. That the Committee for Justice considered Statutory Rule 2014 number 40, the Building Society Special Administration Rules, Northern Ireland 2014, and has no objection to the rule. Agreed?
Agreed.
Then the second one is that the Committee for Justice considered Statutory Rule 2014 number 41, the Building Society Insolvency Rules, Northern Ireland 2014, and has no objection to the rule. Agreed?
Agreed.
Item 9 is Section 8 Guidance for Criminal Justice Organisations and Human Rights Standards. Pages are 143 to 175. We considered the proposal by the Attorney-General to include the PSNI on the list of organisations to which Section 8 applies on several occasions, and we received a range of views from different organisations. The Attorney-General attended a meeting on the 6th of February to outline his response to the issues raised by the PSNI and the Policing Board and the benefits that, in his view, would arise by including the PSNI on the list. Following the briefing, committee requested clarification regarding the mechanism by which the amendment to Section 8 of the Justice Act 2004 would be made, and what remit, if any, the Department has in relation to this matter. Just advise members, the Justice Act 2004 confers the necessary power on the Attorney-General to amend Section 8(4), which is the list of organisations, by an order. Section 21(2) makes such an order subject to affirmative resolution procedure in the Northern Ireland Assembly, and a motion to make the change would therefore be required through the Assembly. The Department has indicated that it has no remit in relation to the guidance or the amending legislation. It has therefore provided information regarding the rationale behind the omission of PSNI from Section 8(4) at the time of drafting of the 2004 Act. The rationale appears to have been to ensure that the police were guided by one document rather than having to refer to several documents, but did provide for the Chief Constable and the Police Board to have regard to guidance in operation under Section 8 when revising the Code of Ethics for police officers. So, members, are members content to support the proposal to include the PSNI on the list of organisations to which Section 8 guidance applies?
Chair, just to clarify, the Policing Board are still opposed to this, is that right?
They had posed questions about how we would monitor and look at the way in which the guidance was being implemented. At this stage was to add it to a list. Obviously the AG would then need to bring forward what the actual guidance would be, which again is subject to this Assembly's approval. So at this stage,
so the guidance goes to the floor of the Assembly, does it?
The guidance comes to this committee.
Yeah.
And previous guidance has done so, and we then have the opportunity to scrutinise it. If we are opposed to it, then my understanding is we can stop it.
Yes.
The guidance itself is subject to a negative resolution rule. So, but the Attorney-General's process has always been to bring any draft guidance to this committee for any views and comments before he finalises it, and I know his officials have consulted with the relevant organisations as well when they're putting it together. But the process would be then he lays the guidance in draft form in the Assembly, but it comes into operation by way of a negative resolution stat rule. So if the committee was totally opposed to it, then you would put down a power of annulment for the negative resolution stat rule if the guidance hadn't been changed, if you had issues when it was being drafted. But the consultation process also allows input into what's in it. So.
That is obviously secondary to the first issue of whether or not to add it to the list. So it's on that question, are members content that it would be added to the list?
Chair, in the Department's writing to us, they're saying, whilst the application of PSNI of the general guidance published in June last year in human rights standards relevant to the protection of the right to life would not run counter to the policy intention, the issuing of specific guidance focused on the interface between PSNI and the public, which would be equally possible if the PSNI were brought within the Section 8, risks giving rise to precisely the circumstances of the original omission sought to avoid. I mean, I think we're trying to do something here which is reversing a situation that was clearly thought out in the first place. I have some concerns about it.
Is there? Do we have to vote now? I mean,
well, only that we have looked at it now, and
I know.
The issue that Mr. Dixon raised is one that was raised with Mr. Organ. Yeah, you know, and so obviously he addressed those concerns. It's whether members are satisfied.
Could we clarify with the Policing Board what their current position is?
Right.
Would that not be satisfactory?
Well, I know what the Deputy Chief Constable's opinion was.
Yes.
Because obviously she communicated that to the committee. Subsequent to that, there was correspondence from the board from the Performance Management Committee, which I think deals with this issue.
Yeah.
And my colleague Jonathan Craig chairs that committee, so I know I've had a conversation with him, and there seemed to be a misunderstanding as to what actually we were talking about, and that was clarified certainly in his mind. But it's an issue that we have kicked about for quite a while. It's whether people have a fundamental opposition to this being added. Obviously, what the guidance subsequently says may well generate debate. Agreeing to it being added to the list certainly doesn't confer an automatic assumption that guidance actually will be applied. And on that basis, I'm content to allow it to be added to the list. But I, like everybody else, would certainly want to see the guidance. So are members content to add it to the list? You're against?
No.
You're content?
Yeah.
Okay. I'm sensing there's a majority of consensus. Well,
Can I be recorded as opposing it then just?
Okay. All right.
Chair, Mr McGuinness made the suggestion that we perhaps revert the matter back to the policing board for further information. I would be happy to support that, otherwise it's indicating opposition.
I think it would do no harm just to clarify with the policing board, and it really doesn't matter a week or two, you know.
I'm in no hurry.
There's been back and forth quite a number of times here, actually.
You see, I get the impression that the PSNI have reservations, but the board hasn't. So
Yes,
you understand what I'm saying? Because you're getting explanations which, you're saying you only agree with the song already what you're doing. So that's where you're stuck between. Like, it doesn't seem to be a. But the police service seems to have an issue, whereas the board doesn't. That's our understanding of it. Maybe they need to just ask now. Are they more content after that?
And my understanding was that the board, in its official formal position, regarded this as unnecessary because it had other guidance.
Yes. That was my understanding. The policing board actually had sufficient, robust regulation in place to deal with this matter.
That's right.
Without adding this on.
Yeah.
I certainly don't accept the argument that has came back from the board that somehow this guidance would be burdensome and in any way curtails them or handcuffs them from doing any of the work that they have presently been doing.
You're probably right, Chair, but we explore that issue. I like the handcuffs, though. It's very appropriate.
All right. I'm happy for us to, if we send back the Hansard transcript that the Attorney General came and addressed a lot of the concerns that I thought they had raised. I ask the board members to review the commentary from the Attorney General, and we will then take a definitive decision as a committee. So I've achieved consensus on that one. Okay. We'll do that.
There's all sorts of dark secrets coming out today.
Item 10, proposals to assess the impact of Department of Justice Legal Aid Reform Package. Pages 177 to 179. Committee agreed at the meeting on the 5th of December to consider how an independent assessment of the impact of legal aid reforms, and in particular changes to family and civil legal aid, could be undertaken, including a possible role for the Criminal Justice Inspectorate. Subsequently, there was an update to the committee on the 13th of February when the Deputy Chairman met with the Chief Inspector, Brendan McGuigan, during which he was receptive to the idea and expressed the view that SIGINI could possibly undertake a piece of work in this area to assist the committee. A paper has been prepared for consideration setting out possible areas and issues to be covered in any assessment of the impact of legal aid reforms, and possible areas include both civil and criminal legal aid, changes that have already been implemented and changes that are being proposed by the Department. So it's whether members have any views on areas and issues that I would like to ask SIGINI to cover in the assessment of the impact, so that we can then write to the Chief Inspector. There's obviously a paper there that was prepared for members. So if you're content with that paper, well then we'll proceed on that basis. Okay. Committee had also deferred consideration of the proposals for stat rules to harmonise the financial eligibility test for applicants seeking civil legal aid until further consideration had been given to the proposed assessment of the impact of legal aid reforms. So members, it's whether these proposals should also be added to the list of areas to be covered by the assessment, and if they should be, whether the committee should decide on these proposals now and assess the impact of the changes once they've been implemented, or whether an assessment of the potential impact of proposed changes is the preferred approach.
That's the financial eligibility?
Yes.
Yeah. Well, I mean, it seems to me, Chair, I mean, the reduction in numbers of people available to or eligible for legal aid amounts, in my calculation, to over 140,000 people. That's a lot of people. I know that they're not all going to either apply for or receive legal aid, but it's an awful lot of people to disadvantage if that is the net effect of this. So I would include that as well.
Okay, do other members want that included then? Yeah.
Yep.
Okay. Okay. We'll yes. Yeah. So we'll defer taking a decision on that until we get this report back. Item 11 is correspondence. There's 9 items in the meeting folder and then 3 in the table pack. Item 4, which I'll draw attention to, is an email from Jim Shannon, Member of Parliament, forwarding correspondence from a private company, Redcap Security Solutions Limited, regarding farm crime and proposals to establish a team to support the PSNI in rural areas. So if members are content to note the correspondence, or whether any further information, including likely cost of the proposal, should be requested from the PSNI. Obviously, it's a private company, so usually we don't get involved in. No. Okay, well then we'll note it. Item 7 is a copy of correspondence from Mr. Ross to the Legal Services Commission regarding the eligibility criteria for legal aid and the assessment of a specific legal aid application. It's just for members to agree that we would request a response from the Legal Services Commission and the Minister of Justice on the issues raised. And anyone who wants to look at the file, it's pretty detailed, and the clerk can make that available to you. Okay, content. Item 8 is correspondence from an individual regarding a family's experience of handling of a recent sexual abuse case. The individual has praised the police officer assigned to support the family and the named contact in the witness care unit, but has expressed concern and anger regarding the handling of the case by the presiding judge and a particular letter issued by the victim and witness care unit following the sentencing. He has stated that the victims in sexual abuse cases need more protection and hopes the committee will implement changes. He's also sent copies of the letter to the Minister of Justice and the Lord Chief Justice. So if members are content, we will write to the Minister and the Office of the Lord Chief Justice on the matter, requesting a copy of the responses they send to enable the committee to consider what further action, if any, is required. Agreed. Item 9 is an invite to the launch of the Probation Board Corporate Plan for 2014-17. It's on the 26th of March at 11 o'clock in the Probation Board headquarters, so members who wish to attend, if you can advise the clerk. Item 1 in the table packs correspondence from the Department advising the Minister has accepted an invite to give evidence on the 4th of March to the Westminster Joint Committee on the draft Modern Slavery Bill and how proposals might interface with similar legislation in Northern Ireland, and that obviously has subsequently taken place. Item 2 is a copy of the CGI follow-up review of corporate governance within the Parole Commissioners for Northern Ireland, which was published on Tuesday the 4th of March. Members were emailed a copy of the report on Monday, so if members are content to note the report unless more information is required. Okay, noted. Any other comments on the correspondence? If not, we'll agree to action as outlined. Chairman's business. The Deputy Chair and I have received an invitation from the Department of Justice to a stakeholder engagement event. It's on the 10th of March to inform the development of a joint healthcare and criminal justice strategy and action plan to comply with recommendation 13 of the prison review team. Fortunately, I'm not able to attend that particular event. The item then that I referred to earlier with the Attorney General, I know some members have spoken with me in light of the discussion that there's been around the on the runs issue, the judge-led inquiry, the Northern Ireland Affairs Select Committee's inquiry, the Policing Board having held a meeting that some members certainly have indicated to me they would be of a view that this committee should be doing a piece of work in respect of this as well. In terms of the initial investigation around this, members have suggested to me that they would wish to have the Minister come to the committee, the Permanent Secretary, Nick Perry, and the Public Prosecution Service Director, Barra McGrory. And also members had indicated they would want to ask the Attorney-General about the legality around the status of the letters, the legality of the scheme, both pre-devolution and post-devolution, and also if this was a matter that should have been transferred to the Department of Justice upon commencement of devolution of justice powers. So that's what some members have indicated to me. Certainly I'm open for other members to make any comment around it. Certainly I'm content that we would do this piece of work, and I would recommend that that's where we would start.
Chair, could I just make one point? I think that we should invite the Minister to come along and make a statement in relation to all of this. I'm not so sure that the Minister has an awful lot of information or knowledge to give to this committee, and I'm not certain that the current Director of Prosecution Service has that much information that he can, as a Director, disclose to the committee. Because as I understand, in private practice, he was involved in certain issues in relation to OTRs. But that is separate, and he's bound by confidentiality in relation to his clients and so forth. So, and he did indicate in terms of dealing with contentious issues before he took up the position that he would have to delegate his good offices to another member of staff, presumably his deputy director. So I'm not certain that there's much value in that. In relation to the Attorney General, I think there's value in listening to what the current Attorney General can tell us. I'm not so certain that it's an awful lot, but in terms of his legal expertise and assessment of the situation, I think that might be useful. But beyond that, I'm not certain that there's an awful lot more we can do. And I do agree that the Permanent Secretary of the Department should also attend.
Yes, Mr. Dixon.
Chair, thank you. I don't agree. I don't disagree with Mr. McGuinness in terms of drawing those people on behalf of others to the committee. I think, though, the timing is probably something we do need to consider in respect of this. The judge-led inquiry, and just noticing here the Secretary of State has made further comment about it today. The judge-led inquiry is the Prime Minister's response to the situation. That, together with the Northern Ireland Select Committee, a committee which has vastly wider powers than this committee has, and much deeper in terms of calling witnesses. Chair, in terms of dealing with the issue, would this committee not be better served if we waited until both of those elements were over? And indeed, all the people that Alban made reference to undoubtedly will be called. Indeed, the Select Committee, I'm sure that the judge may not have powers to call people out. I'm not sure whether that's clear or not. But certainly the Select Committee has absolute power to call all of those people. And they, maybe some of them wouldn't want to come voluntarily. And once all of that is done, would we not be in a wiser position to take both of those reports and then assess it from our perspective at that stage, rather than, I mean, all the questions that you're going to ask will inevitably ask by the judge and by the Northern Ireland Committee. The people are going to be asked at that stage on 3 occasions, and I think also the Policing Board are going to do something as well. So all I would do is say I think the concept is a good one, but I would suggest that it might be better for us as a committee to act as the sweeper in this case rather than to be out in front. It's just a suggestion.
Thank you. Mr. Elliott.
Chair, I think I slightly disagree with Stuart on that point, because I think what you're talking about is not a full-blown inquiry. I'm assuming it's trying to get as much information in as short a time as possible to satisfy ourselves to hopefully progress it, because I'm assuming the reports will not be, come out in the very near future. So I think it would be helpful.
She says May.
Okay, well, it's still a couple of months away. I think it would be helpful for us in the next couple of weeks at least to establish some of the background of what our own department knew in respect of this. So I would have no difficulty with that. We're not going into the same type of process as either the Northern Ireland Select Affairs Committee or indeed the judicial process. So I think it is different, and I would support actually at least asking the Minister and the Permanent Secretary up for now, and try to establish, and indeed the Director of Public Prosecutions, just to see what he knew in his role, or what he can tell us about his role as Director of Public Prosecutions. Nothing to do with no effect of what he's done in the past prior to that. So I would support that, Chair. And maybe, maybe even the Secretary of State would be willing to come up and give us some views at this stage even as well.
Where our powers are restricted is, I don't think we can compel.
No.
We can ask. We can't compel a Minister of the Crown, in that sense, a Secretary of State. We certainly have the powers of compellability, but
I don't think we'd like to compel any of them, Chair. I'd be hoping that they'd come up voluntarily anyway at the invitation.
Although, Chair, if they said to us, look, they are in preparation for those other two major events, it may very well be that the response we would get, it is up to them, I accept that, but the response that we may very well get is that they would prefer to give their evidence, first of all, to the two created issues, bodies that are there to deal with the matter at the moment.
Yeah, and
we're sort of coming along a bit late, but there's no issue with that. I think we do have a genuine role at the end to assess where the final outcome of all processes. And that probably puts us in a very strong position.
It's certainly my interest in the Director of Public Prosecution Services to find out what governance arrangements he did put in place to avoid the conflict that very evidently existed for him.
And he's going to tell all those other people as well.
And I know he's obviously been on BBC's The View to explain himself. I would like this committee to have a role in that as well. Mr. Humphreys,
Chair, I have to say, I very much agree with Mr. Elliott, because, I don't know what other members have had in terms of their mailbag or in terms of people phoning their offices, but I've got a considerable amount of people who have contacted my office around this issue, and I think there needs to be clarity and certainty around it. And I'm not, for a moment, naive enough to believe that everybody will agree around this table as to whether there should be an investigation or an inquiry or whatever shape it takes. But I, from my perspective, want to know more about it, because I think there are people there who need to be questioned, and Police and Board can do whatever. There is a judge-led inquiry, and there is the House of Commons Northern Ireland Select Committee inquiry. But I think people would find it rather bizarre that the Northern Ireland Justice Committee wasn't actually involved in some sort of investigation around it. And we also have to remember this: not every party in this Assembly has seats in the Northern Ireland Select Committee, or don't either attend or not elected to Westminster. So we have to bear that in mind as well. I think this is an issue of public confidence in these institutions and public confidence in the democratic process and the principles of democracy. And from that point of view, people out there want certainty, they want clarity, they want transparency, and we all signed up to that. And so, as far as I'm concerned, as far as my party is concerned, we would very much support the suggestions that you've made, and asking those. And I agree about the Secretary of State as well. I read the Secretary of State's statement, and then I heard her interview, and I was really confused as to what exactly her position and Northern Ireland Office position was. I was part of a delegation, as you were, and Mr. Anderson was, and met the Junior Minister, and I didn't get any certainty as to what his position was, what he knew. And so therefore, as a member of the Northern Ireland Assembly, sitting in this place, I want to know exactly what was agreed, what wasn't agreed, and who was involved on all of those questions. And these people should have nothing to fear about coming forward to this committee. I also have to say it's our legislative responsibility to question these people, and I think we'd be failing if we didn't.
Mr. McCartney?
I suppose the only thing about, the Police and Board, the Select Committee and ourselves, it just points up what is apparent is the inadequacies of the judge-led inquiry, despite people thinking it was going to be the answer to all of this. We have no issue if people want to bring people in front of the committee, but I think it would be worthwhile. I know if whether or not we can compel the British Secretary of State's one thing or another, but certainly the British Attorney General has submitted an opinion to the British Parliament and to the court in relation to this. So I think that should inform all that we do. So I think maybe perhaps we should be asking for a copy of his opinion, and perhaps maybe invite him as well, because I think the Attorney General today, in very frank terms, is not make of, but so he may have not too much to say, or may not want to say too much because he hasn't got the facts of the case. But the British Attorney General perhaps would be a very informed and very informative witness to bring in front of the committee.
Certainly, I would, if I could get the English Attorney General here, I'd be delighted. I suspect he might be one on the list.
That's wishful thinking.
Yeah, I think he might be one on the list who would say, sorry, not your jurisdiction, but I'd be more than happy to extend the invite.
Well, certainly we should get his presentation to both the court and to the British Parliament.
Yeah.
In preparation for certainly Nick Perry coming, I would like to get a copy of the Civil Service Code of Conduct, which is being relied upon as the rationale for not informing once he became the DOJ official. I think it would be useful to inform ourselves of that, so that when we are questioning him, we have that available to us and understand it. Okay. Well,
Jerry, just in relation to Nick Perry, like it's not just as simple as one minister transferring to another department. This is a case of devolution, taking a whole basin of justice over. But it may be different, and I certainly agree with you that there has to be some work done in relation to the code of conduct that Nick Perry, the Permanent Secretary there, was involved in. We need that to see what he is allowed to tell us or not tell us.
Okay.
So I think that needs to be done.
Okay, well, then I'm going to take it members are content with my initial recommendations, and we'll proceed and seek to get witnesses as early as possible to their availability. And we will seek to invite the English Attorney General and the Secretary of State. Any other business? No other business? Okay. Meeting adjourned.
Committee room 30.